We now move to our third speaker, Gowaart van den Bossche, who has 2 MAs. He has an MA in history and another MA in Arabic and Islamic Studies from Ghent University. He's currently also pursuing his PhD at Ghent University, and he's going to present a paper entitled Destroying Churches by Performing Knowledge, a social discursive reading of Ibn al-Rifʿa's Kitāb al-nafā'is fi adillat hadm al-kanā'is.
Thank you very much. And to continue the trend, I will also be presenting something that doesn't really have anything to do with my PhD research. Although in general terms, it is on similar subject in the sense I'm looking at social performance. I would like to thank the organizers for accepting our panel, and for Luke and Mohammed for contributing to the panel and also giving many helpful suggestions for my own paper. Mohammed especially for reading my very faulty edition of the Arabic text and giving some 300 corrections to it. So that was very helpful, thank you. Okay, so I will be talking about a text called Kitāb al-nafā'is fi adillat hadm al-kanā'is. It's written by the Cairene Shafi jurisprudent Qadi and Muhtasib Najm ad-Din Ibn al-Rifʿa, who died in 1310. You can see the frontispiece of the book. Here it's quite difficult to read in this light. You sort of, but it says what the title says next to it. There is only one copy of it. It's in the Azhar library, and it's dated to 1301 to 26 Sha'aban, even, so it's very precisely dated, and presumably it's an autograph because it's as we will see, this date follows immediately upon the historical circumstances with which it's associated. Now, while at first sight this text seems to be a rather standard treatise of fiqh, I will argue in this presentation that it is interesting to look at this text from a social discursive perspective, focused less on the contents of the arguments, which are very legal, and more on the ways this text applies knowledge as cultural capital in negotiating social authority. Inspired by the work of Michael Chamberlain, who has inspired many of you, as I've been hearing the last days, and those who have followed in his footsteps, I will here look at this short text from an angle of social competition and knowledge contestation, and argue that Ibn al-Rifʿa was interested at least as much in challenging the application of Shafi'i fiqh by his colleagues as he was in challenging Christians and Jews directly. In doing so, Ibn al-Rifʿa not only expressed discontent at the ways in which rules, or hukm and ahkam, were formulated by his colleagues, he also performed his claim to superior knowledge of the principles and techniques of rule formulation, or tarjih, in his madhab, which can be linked to power struggles among the ulama in Cairo at a time of considerable flux in both political and juristic circles. I will first give some general information about the text and its genesis, and then move on to an analysis of a number of excerpts that give insight into the author's social intentions. As to Ibn al-Rifʿa's complex 5-part argumentation, suffice it here to note in general that it revolves around the question of who should be the plaintiff and who should be the defendant in the case of whether churches should be destroyed or not in Cairo, considering the fact that this city was built long after the region was conquered by Islam, which also was conquered on Watan, which is something Luke also mentioned earlier. So Cairo was apparently conquered by force. Well, Egypt, I mean. By scrutinizing various important works of Shafi'i fiqh on this matter of plaintiff and defendant, our author concludes that the apparently widespread opinion that the ones who want to destroy a church or synagogue should first provide evidence for the building's recent construction is completely mistaken. He says it's just plainly wrong. If you look at the works of fiqh, it says those who want to preserve the church should give proof of the building's existence before Islam. So basically he's saying you're guilty until you're proven innocent, which seems contrary to our views, but he argues quite persuasively to the contrary, at least in terms of fiqh, of course. As far as I know, the treatise has only been studied in detail by 2 earlier scholars, and mainly actually only by one in detail, which is the first one by Seth Ward, who wrote a short article about it. But it's relatively problematic in the sense that Seth Ward didn't actually read the original text. He read a summary of it by Taqiyuddin as-Subki, which preserves the main argumentation, but I'm not sure it actually preserves the discourse of the original text, which has quite big implications for what I'm arguing as opposed to what Steph Worf is arguing. Kristen Stilt also consulted it in the original, but she didn't really find much material that was useful for her dealing with the muhtasib, even though Ibn al-Rifʿa was a long-serving muhtasib in Fustat. So in essence, there hasn't really been much work on this text at all, though it has been mentioned in passing by a few other scholars, such as Tamar al-Laythi, but I think he also didn't consult the original text. So while it is useful to read this treatise in the context of polemical text and the contemporaneous tensions in which it originated, which is what Seth Ward does, he contextualizes it in the context of these tensions. The contents of al-nafā'is are actually quite peculiar and deserve closer scrutiny. For one, the text does not contain any of the exemplifying anecdotes or hadith about Jews or Christians, which you usually find in polemical texts. It only quotes 2 Quranic verses that refer directly to non-Muslims, and plenty of others that refer to more legal matters. Instead, the treatise consists almost entirely of Shafi'i legalistic discussion. Secondly, while our author does refer often to Jews and Christians and their houses of worship, these are not really addressed as direct opponents, but rather as a group of people outside of the discussion, mostly. There are a few times when he does address them directly. It seems he presents them as a group that has to be indirectly defended by those opposed by Ibn al-Rifʿa, so by his colleagues, in essence. Nor was he addressing the political authorities in a textual form related to advice literature, as has been argued for the polemical treatises of the period. Instead, Ibn al-Rifʿa apparently considered the weight of decision concerning the matter of churches to lie entirely with the ulama, which is interesting because it resonates with Luke's fatwas, where apparently some laid the weight of decision with the imam or the sultan. Ibn al-Rifʿa does not even mention the sultan at any point. He's not interested in the authorities. It's entirely a matter of the ulama discussion. Now, making such a decision based on fiqh involved the correct deduction of principles of law. And it is actually this problem with which the text is in the first place concerned. And as such, it lies more in the domain of fiqh than it does in that of polemical writing. Now, as for the context of the text, a number of chronicles give some information about the genesis of the text, which also helps to place it in its context of inter-ulama knowledge contestation. The 2 main chroniclers who give some information about Ibn al-Rifʿa's struggles are al-Yunini and al-Maqrizi, who both mention a council in which the text was discussed. Al-Maqrizi's account runs as follows. The common people laid their hands on the churches of the Christians and the synagogues of the Jews, destroying them in accordance with a fatwa by the Sheikh and jurist Najmuddin Ahmad ibn Muhammad ibn al-Rifʿa. The emirs then asked the qadis and the jurists to investigate the question of the churches. So notice here as well that apparently the emirs immediately gave the matter to the ulama. They didn't want to deal with it. When they were gathered, Ibn al-Rifʿa made a statement about the necessity of destroying them, i.e. the churches, but the chief Qadi, Taqiyuddin Muhammad ibn Daqiq al-Eid, who we will meet again later in this my presentation, forbade this. He alleged that if proof can be procured that the churches and synagogues had been built after the conquest of Cairo by Islamic conquerors, they should be destroyed. But if such evidence cannot be procured, they should not be interfered with. I.e., this is the opposite opinion of Ibn al-Rifʿa. This is saying you are innocent until proven guilty in this context. The remaining judges and jurists agreed with him, i.e. Ibn Daqiq al-Eid, concerning this and then dispersed. So it's clear that Ibn al-Rifʿa's opinion was not followed by the community of jurists. Now this account reverberates quite interestingly with the tone of Ibn al-Rifʿa's treatise, which is here mentioned as a fatwa, which is a complex matter in itself. It's not entirely clear if the text we have is the original or is a reworking of a fatwa, or maybe even just is a fatwa, but lacking the actual question. So what's mentioned here helps to interpret his arguments as in the first place addressed to his jurist colleagues, as a contestation of their application of deduced principles to formulate substantive law. A number of comments throughout the text are especially suggestive and will be the focus of the remainder of my discussion today. Here, Ibn al-Rifʿa is not merely voicing his opinion, but actually accusing other jurists of being too lenient, even incorrect in their application of fiqh. Consider, for example, these opening lines, which, interestingly, are in Sajja. Actually, there is a general introduction of about 2 pages, which is entirely in Sajja. Now, I'm quite used to Sajja because I usually work on quite literary texts, but I'm not sure if it's common to use Sajja in fiqh treatises. So I would be very interested to hear from anyone who has worked more on these type of texts if it is common to use this. But in any case, this is, you can see it by the end rhyme, da'wa, jadwa, fahwa. And I have translated this as the here presented indicant from which legal norms or rulings, ahkam, should be derived is in answer to legal claims made in Cairo al-Mu'iziyah, which will not come to light if God wills it by his help and strength, which provides benefit, and is based upon the statements of a Shafi. May God have mercy upon him and send him along as companion of the text and the meaning. So, what's interesting here is that no mention whatsoever is made of the churches in this programmatic first sentence. It is much more the idea of contestation of earlier legal claims that is posited here and that permeates the text's further discourse. Consider, for example, this statement found after our author has made the first major point concerning a Shafi's position on the matter of the plaintiff and defendant. Which I have, well, so this translation is actually a bit faulty. I edited it today, yesterday actually, so I will read the right one, or the more correct one. Most of these translations are relatively tentative, so I'm also very much open to suggestions. I am of the opinion that it is incumbent on the one complying with a Shafi's opinion and the one following his madhab to deduce what is useful of unwritten substantive law, just like a Shafi's companions deduce the substantive law that we follow. Similarly, further on, he refers to 2 opinions of a Shafi on a dispute about possession as follows. It is known that a Shafi has 2 opinions about this, which obliges the one formulating an opinion to follow these opinions in accordance with the madhab he adheres to. Another similar excerpt is this one, which is a rather complex sentence, and this is actually just before the only time in the text he directly refers to Ibn Daqiq al-Eid. And then he writes, the correct opinion, as it is related by those traditioners whose opinion is relied upon in the transmission of the law schools, in accordance with which their adherents must act and resort to in fatwa, is that the Egyptian lands were conquered by force. So you have that critical point of Unwatan here. Now, all these 3 statements include the words muqalid or muqalat, which is of course linked to taqlid, the obligation to follow established doctrine of the madhab to which one belonged. Now, while this concept is a subject of much debate among scholars of Islamic law, especially in relation to ijtihad or independent reasoning, it is not really my intention to discuss this at length, as I am here only interested in the way it shaped Ibn al-Rifʿa's argument. What is clear from these quotes and from the general argument, which calls for the direct deduction of principles according to madhab tradition, is that our author considered taqlid the only viable option to deliver a ruling, at least in the context of this treatise. Further research on in his other writings would be necessary to see in how far he actually adheres to taqlid as the thing to do. The only moment when he refers to ijtihad in this text is when he talks about the Caliph Umar ibn al-Khattab's ruling concerning the status of the lands of southern Mesopotamia in the context of a long discussion about the status of the churches and synagogues in Basra. So implicitly, and like many scholars of his age, Ibn al-Rifʿa seems to contend that true ijtihad was a thing of the past, and that it is incumbent on his colleagues to base rulings firmly on taqlid. Now, it's important to note that not everybody at the time held to this belief, but Ibn al-Rifʿa quite firmly says that taqlid is the only possible option in delivering rulings. Now, all of this might seem relatively commonplace for a juridical text of the period, which has been called the Age of Taqlid by Yossi Rapaport. Yet the specific tone of the argument and the ways in which Ibn al-Rifʿa posits his own claim to knowledge based firmly in taqlid, as opposed to knowledge propounded by mostly unnamed peers, aside from the one short reference to Ibn Daqiq al-Eid, making it an interesting work on the level of social practice. My suggestion is that Ibn al-Rifʿa was not merely formulating an opinion in the intrinsically dialectical context of usul al-fiqh, he was actually contesting the authority of his superiors or his colleagues and negotiating his own position with respect to that authority. If, again in following Michael Chamberlain and his use of Pierre Bourdieu's theoretical framework, we interpret knowledge as a form of cultural capital applied in social competition or social survival, as Michael Chamberlain calls it, we can interpret Ibn al-Rifʿa's claim to superior knowledge of usul al-fiqh and furu' as an application of such capital, and the performance of his status as a leading jurist whose interpretation of fiqh should be followed by the general community of ulama, or at least those of Shafi'i stock. It is unclear whether Ibn al-Rifʿa tried to achieve the establishment of his opinion as authoritative in this matter only, or whether he was trying to negotiate his social standing among the leading ulama of Cairo at large. Some circumstantial evidence does point towards the latter option. His relatively high position in the local Shafi'i hierarchy as an assistant judge, and the fact that he was at one point selected to debate Ibn Taymiyyah as a representative for the Shafi'i madhab, shows that he was quite successful in attaining that leading position. Ultimately, however, his efforts came to nothing, as might be inferred from the following account in al-Yunini's Chronicle, which is found right after the account about the sumptuary laws, in which then you have the 1301 struggles, in which sumptuary laws are instated, and which this text was also written. Where the chronicler, so al-Yunini, mentioned the Council of Jurists, and then a little bit later he moves on to deliver the following account, and I quote from Ligo's translation, although I have altered it a little bit. In the month of Ramadan of this year, 700 Anno Hijriya, the Shafi'i jurist and court functionary Najmuddin Muhammad ibn Aqil ibn Abi Hassan al-Balisi, a Damascus native, was appointed to the office of Deputy Judge of Egypt. He was to succeed the Chief Judge Taqiyuddin ibn Daqiq al-Eid, rings a bell, as he assumed the position. Qadi Najmuddin ibn al-Rifʿa, rings even more of a bell, was unhappy and thus left the office of deputy judge and resigned from the post. Ibn Daqiq al-Eid thus appointed Qadi Zayn ad-Din Umar ibn Sharaf ad-Din ibn Yunus al-Qinani, which could be actually a misreading here by Ligo, and could be al-Qattani, which is the same mufti, which is one of the muftis that Luke actually just presented, to replace Ibn al-Rifʿa. He assumed the post in Ramadan as well. So why exactly Ibn al-Rifʿa was unhappy and resigned is not explicitly stated, but I think it is likely that he had been hoping to receive the honor of succeeding Ibn Daqiq al-Eid himself, especially because he was a highly placed deputy judge. Could we even connect this resignation to Ibn al-Rifʿa's failed attempt at having his opinion on churches gain wide acceptance and its ultimate rebuttal by Ibn Daqiq al-Eid? Did his relatively forceful challenge of the predominant line of reasoning among elite ulama concerning the churches make his position as deputy judge untenable? Or was it just the last in a series of conflicts with fellow ulama in which he seems to have been involved, as reported in various biographical dictionaries? We don't know. In any case, from the totality of all these accounts about Ibn al-Rifʿa, vague though they may often be, and the tone of the short but dense text of applied fiqh on the churches, we can reconstruct a fascinating picture of one-agent social struggles in the late 13th and early 14th century Cairo, and the dynamics of contestation and the production of knowledge and authority among the community of leading ulama in particular. This contestation and that production were clearly fiercely debated on many fronts, and while it was perhaps not on the level of ijtihad, the stakes of the debate were clearly multifaceted, with authors offering widely diverging views even though they relied on similar practices to establish substantive law. Thank you very much.
Thank you very much to all three speakers.